Many thanks, Justus, for making this event possible today. It's a great pleasure for me and all of us to be here. As you said, one of the reasons why we do this today is to discuss your tremendously interesting study, but also to let people know and share parts of the content of our book, FRAND, the German case law. I edited this book together with Tom Cotter and Erik Habich. And why did we do that? A lot of work, but we thought, while all of you in the audience are certainly aware of the importance of Germany as an SCP litigation hub, and although all of you will know a lot about German case law, it is still not all that easy to pull together all the, in particular, lower court decisions. And more importantly, it's not easy to keep track of what is going on amidst the flurry of decisions. So we thought a more extensive update of what went on since Huawei's FTE would be warranted. And also we wanted to put this German FRAND case law into perspective, into a global perspective, by asking mainly high-profile judges from around the world to comment on, from their perspective, on this case law. And we are very happy that judges like James Robart or Richard Arnold or Patricia Romba from the German Bundesgerichtshof, Matthias Siegern, who will be with us today, also Wang Liangchang from the Chinese court, that they all agreed to write something on how they see German case law in a global perspective. So we think it was worth doing this, and we certainly look forward to now sharing a little bit of our insights with you in the webinar and discussing with you and the other speakers later on. With that, I would already hand over to Tom Cotter for his input. Thanks, Tom.
Thanks. And actually, I think, isn't Erik, you're going first, I believe, aren't you?
Yeah, thanks, Peter. I'll first start with a short overview of the case law part of our book. In the case law part of our book, we have reviewed the German FRAND case law, starting from the Federal Court of Justice's FRAND Einwand 1 decision, and also selectively some earlier case law, until the case law around mid last year. And we grouped the case law on topics such as the willingness to license, the FRAND offer, reaction duties, and the counter offer, damages, confidentiality, and SAP transfer, as well as anti-suit injunctions. And in the next few minutes, I will point out some more general characteristics of the German FRAND case law, as was developed by the Federal Court of Justice, to pave the way for our later discussion, before Tom will give an overview of how FRAND is approached in other jurisdictions, and most prominently the United States. So as a preliminary remark, I will discuss the entitlement mechanics as they have emerged in the FRAND case law of the Federal Court of Justice. For this, I will use the concepts of property rule and liability rule protection of rights, with property rule protection meaning that the entitlement is protected by an absolute right to exclude others. And in the FRAND context, this means the grant of a prohibitory injunction, versus liability rule protection, meaning the absolute right is allowed to be compromised by anyone against compensation for the harm suffered. In FRAND context, this means the use of a patent against reasonable royalty. And as the mechanism was developed by the Federal Court of Justice, and in contrast to the US case law, where Professor Cotter will give us an overview later, the German case law in general let the exclusionary right from the patent prevail, meaning that a prohibitory injunction is granted as a principle. And there are two exemptions to this property rule paradigm. Obviously, if there is a licensing agreement between the parties for the use of the patent, And secondly, if the infringer is willing to take a license on FRAND terms, and therefore then it may continue to use the SEP for the purpose of the negotiations. And in this regard, instead of the property rule, a liability rule will apply, meaning the infringer can use the SEP against a reasonable royalty, either by way of future agreement or damages in court proceedings. And as a result, the mechanics of the German FRAND case law can, in my view, be described as follows: that it is a property rule, the patent is protected by a property rule, intertwined with a purpose-driven liability rule, and the purpose is, over the course of negotiations, to crystallize towards a licensing agreement or property rule protection of the patent. And what the German FRAND case law does is it specifies this dynamic balance of property and liability rule entitlements to the SEP, so that willingness to license and the requirements on the patentee, according to the Huawei scheme, are to advance the crystallization of this property rule protection to the SEP. So what this means more specifically, in its FRAND Einwand decisions, the German Federal Court of Justice developed a two-pronged approach to abuse, as many of you will know, when reviewing the antitrust compulsory license defense. And as a first prong, the court mentioned that the SEP holder will act abusively if it pursues a prohibitory injunction, even though the infringer made the licensing offer on conditions the patentee cannot reject without abusing its dominant position. And the court, for this purpose, referred to its previous Orange Book standard case law. And alternatively, as a second prong, it may be abusive if the SEP holder pursues a prohibitory injunction if the infringer has not yet agreed to conclude the licensing agreement on certain reasonable terms, but if the patentee is to be blamed for not having made sufficient efforts to enable an infringer who is willing to conclude such agreement on reasonable terms. And for this second prong, the FCJ referred to the ECJ's Huawei ZTE case law. And what we can take along from both of these prongs, and also from the subsequent German case law, is that willingness to license, and in particular willingness to negotiate a license, is at the core of both of these prongs. And this contrasts with some earlier German case law before FRAND Einwand, where willingness to license was regarded as a requirement as well, that was more similar to a lip service requirement at the outset of negotiations, while the core of the substantive assessment was the terms of the offer or the terms of the counter offer. So this leaves us with the question what this unconditional willingness to license on FRAND terms actually means. And the Federal Court of Justice told us that unconditionally willing to license is who does whatever a reasonable party interested in concluding negotiations by an agreement in the interest of both parties would do to promote the finding of such agreement. For the SEP holder, this means willingness to enable a willing implementer to negotiate FRAND terms, meaning the second prong we just discussed, and as well as willingness not to insist on non-FRAND terms, referring to the first prong. For the SEP implementer, however, willingness means to unconditionally take a license on whatever terms may in fact be FRAND, and to negotiate such FRAND terms, in particular not pursue delaying tactics. And the only permissible condition that is with the willingness to license, meaning to license on FRAND terms, narrows down and crystallizes by way of cooperation throughout mutual negotiation. This leaves us with a question of what happens if not both parties are willing to license in the sense just explained. First of all, we must note that the ground of an injunction or the successful compulsory licensing defense will only become relevant in negotiations if these negotiations have not produced an agreement at the time of the judgment. And if the SEP holder fails to comply with either abuse prong, while the implementer complies with its duties, its infringement suit may be regarded currently unfounded, and the compulsory license defense of the implementer will prevail. And furthermore, the reactions of the SEP holder may influence the reaction duties of the implementer. For the implementer, however, if it is only conditionally willing or pursuing delaying tactics, it may be found an unwilling licensee, meaning that an injunction against it will be granted. This will be based on an overall assessment, and the German case law was generally open to allow the implementer to catch up on reactions that have not lived up to the rather strict willingness standards we just discussed of whatever a reasonable party interested in concluding negotiations would do. Professor Picht will mention the recent amicus letter of the EU Commission in this regard at the end of our presentation, and this may certainly be a topic for later discussion. Yet the German case law has also voiced that catching up may influence the requirements of the implementer's reactions and counteroffer, and as a result, if catching up was permitted, the compulsory license defense may still prevail, or ideally a licensing agreement will be struck. As a final remark, I want to point out that the Federal Court of Justice not only views negotiations as serving the purpose for their prospective outcome, meaning an agreement, but also as a means to identify the interests and arguments concerned when judicially determining whether the parties complied with their FRAND duties. So with this concluding remark, I will hand over to Professor Cotter, who will contrast this German approach to FRAND against the US approach and approach in other countries.
All right, thank you, Erik. So as Erik said, I'm going to spend the next few minutes comparing and contrasting the German approach to FRAND litigation with the approach followed in the United States. And I will also say a few words about developments in the United Kingdom and China as well to illustrate where the German perspective fits into the overall global picture. So to begin, there are many differences between German litigation and US litigation just as a general matter. First, the United States, unlike every other country I am aware of, still uses juries to decide many complex civil actions. And so accordingly, many of the US FRAND cases are decided by juries, which as a practical matter, introduces a degree of unpredictability and affects case management. Second, for the most part, the United States, unlike many other countries, does not have specialized trial courts for the most part, or specialized chambers within courts of general jurisdiction. We do have a specialized appellate court, as I'm sure many people in the audience are aware, the Federal Circuit. We have some specialized forums, such as the International Trade Commission, but by and large, patent infringement litigation is conducted before courts of general jurisdiction. Some of the judges have considerable experience with patent matters, others do not. And so in general, this is a difference between litigation, patent litigation in the United States and in many other places where there may be specialized trial courts, such as the Patents Court for England and Wales, the Unified Patent Court, the Beijing Intellectual Property Court, or alternatively, as in Germany, France, many other countries, specialized chambers or senates within courts of general jurisdiction. A third respect in which there are differences is the emphasis on pretrial discovery and expert witnesses, including expert economists in FRAND cases. We do certainly encounter expert witnesses in other countries, common law countries in particular, but the use of experts, I think it is fair to say, is less emphasized in the civil law jurisdictions such as Germany. And then in patent litigation in particular, one salient difference between the United States and Germany is that we do not bifurcate infringement and validity decisions, neither does the UK, but we know that that is a feature of German patent litigation, also patent litigation in China. But focusing on FRAND litigation in particular, however, I think the two most important differences are, first of all, the role of antitrust or competition law, and secondly, the availability of injunctive relief. So Erik, if you can advance to the next slide, please. Thank you. So as for the first matter, the antitrust one was actually supposed to come next. Did they get out of order? There we go. So FRAND litigation in the United States can proceed along various tracks. In many cases, it'll be patent litigation just as a general matter. The patent owner sues an implementer for the infringement of one or more FRAND committed standard essential patents, and the case proceeds more or less as a standard patent infringement action with the question of remedies, an injunction, or a court-determined royalty, decided largely as it would be in any other complex patent infringement case. Another possibility is that the action proceeds as a breach of contract suit brought by the implementer under the theory that the FRAND commitment creates a contract for the benefit of third parties, which the patent owner has violated by demanding un-FRAND terms. And that was the theory that was employed by Judge Robart in the Microsoft versus Motorola case back in 2012, 2013, which was the first case in which a U.S. court determined the royalties due for a portfolio of FRAND committed SEPs. In other cases, the patent owner may sue for a declaratory judgment that its offer is FRAND and that the implementer's counteroffer is not. But in very few U.S. cases has antitrust played a dominant role. And for the most part, the U.S. courts have rejected claims that the patent owner's conduct relating to FRAND committed SCPs violates U.S. antitrust law. And I don't necessarily endorse all of the U.S. decisions that have reached that conclusion, but it is fair to say that this perspective is consistent with the general thrust of U.S. antitrust law. Under U.S. law, the willful acquisition or maintenance of monopoly power can sometimes be an antitrust offense, but the mere exploitation of lawfully obtained monopoly power is not. And we have no general abuse of dominant position doctrine, as many countries do. In regard to the role of antitrust law, the German case law and the case law in many countries is quite different. So in German FRAND disputes, as you have already heard, after some initial period of negotiation, the patent owner files suit for infringement and typically will request injunctive relief. The implementer may then respond with the competition law defense based on the Court of Justice's opinion in Huawei versus ZTE, as further interpreted by the German Federal Supreme Court in the FRAND Einwand or Sisvel versus Higher decisions and other decisions of the German regional and higher regional courts. And the resolution of the defense centers, as you have heard, on whether the SEP owner and the implementer have complied with the required steps of the FRAND dance, as it is sometimes referred to, as set forth in Huawei. If the SEP owner has failed to comply, then its request for injunctive relief constitutes an abuse of dominant position, and it is precluded from obtaining an injunction. But as you have heard, and you'll hear more about this in the coming hour, it is actually quite uncommon for the implementer to prevail in showing that the SEP owner has failed to satisfy its obligations. It is much more likely that a German court will find that the implementer was an unwilling prospective licensee, which then leads to the conclusion that the implementer will be enjoined if the court finds the patent in suit to be infringed. Again, though, this inquiry is considered to be an aspect of competition law. Other aspects of German patent law, including the possibility of a compulsory license under Section 24 of the German Patent Act, or a stay or denial of injunctive relief for undue hardship under the 2021 amendments to Section 139 of the German Patent Act, so far have played no role whatsoever in FRAND cases, and as of right now, it appears that will continue to be the case. So now if we could move on to the slide on injunctive relief, that's the other aspect in which U.S. courts differ from their German counterparts in a very fundamental way. So as I mentioned, in the US, these cases may come before courts either as patent infringement actions or as breach of contract actions, or sometimes both. And in US patent infringement cases, courts apply the eBay factors to determine whether injunctive relief is appropriate. And so as a result, injunctive relief is much less common in US patent cases, even in comparison with other common law jurisdictions, such as the United Kingdom. And while there is no bright line rule that forbids courts from entering injunctions in FRAND cases, under the court's application of the eBay factors, that is not a likely outcome. Most of the time, courts will conclude or would conclude that a court or a jury determined FRAND royalty would constitute would be an adequate remedy, and that the implementer would face undue hardship if it were to be enjoined. And we see a similar outcome, I would say, in the English FRAND cases, where since Unwired Planet, courts have taken the position that once the implementer is found liable for infringement, it faces a choice. It can either be enjoined from practicing the patented technology in the UK, or it can agree to allow the court to establish the terms of a FRAND license, often a global license. I'll talk about that in a moment. In Germany, however, nothing remotely similar to that has happened thus far. There are no cases in which German courts have determined a FRAND royalty or the terms of a FRAND license. In most of the cases, the German courts have decided, they have concluded that the implementer did not satisfy its obligations under Huawei and have issued injunctions. In the minority of cases in which that has not happened and the courts have denied injunctive relief, the parties have settled the matter themselves. And all of this is consistent with what I perceive to be the overall German perspective, which is that the parties should, to the extent possible, be encouraged to work matters out for themselves. They should be the ones determining the terms of a FRAND license, not the courts. In the US, the UK, and also China, by contrast, courts have been willing to take that role on themselves. And so the last matter I would like to talk about, if we can move to the next slide, is global FRAND licenses. Some of the US decisions establishing the terms of FRAND licenses as a matter of contract law have set global FRAND rates, but it is unlikely that a US court in a patent infringement action standing alone would set a global FRAND rate. It might establish the rate applicable in the United States, but probably would view itself as lacking the jurisdiction to adjudicate claims arising under foreign patent law. In the UK, by contrast, courts have taken the position that because FRAND licenses are global in scope, the infringer should be given a choice. If they have infringed a UK patent, they may either be enjoined from practicing in the UK market altogether, or they may authorize the court to determine the terms of a global FRAND license. And so we have seen that happen in a series of cases now, beginning with Unwired Planet in 2017. Predictably, courts in China soon followed suit, and in several cases have determined or expressed their willingness to determine global FRAND licenses. And this, in turn, has given rise to cases in which a party will request that a domestic court enter an anti-suit injunction, prohibiting its opponent from litigating or enforcing a judgment in another jurisdiction. Now, to be sure, anti-suit injunctions predate the Chinese court's involvement in FRAND cases, often have nothing to do with China. In 2012, for example, Judge Robart in the United States entered an anti-suit injunction in Microsoft versus Motorola, prohibiting Motorola from enforcing a judgment in Germany that, as a practical matter, would have forced Microsoft to abandon its US breach of contract action. Needless to say, anti-suit injunctions often do not sit well with the courts that are effectively deprived of the opportunity to adjudicate cases that may be pending before them. And they have been traditionally strongly frowned upon in civil law jurisdictions such as Germany and more generally the European Union. Anyway, though, in recent years, the use of anti-suit injunctions in FRAND cases has given rise to a countermeasure, the anti-suit injunction by which a court may order a party before it not to seek or enforce an anti-suit injunction in another jurisdiction. The German courts have been willing to enter anti-suit injunctions in some FRAND cases, and some German courts also have expressed the view that an implementer who seeks an anti-suit injunction may be considered an unwilling licensee and therefore may be liable to be enjoined from participating in the German market. And so this development has, in my view, reduced the number of litigants seeking anti-suit injunctions in the United States or China over the past couple of years. Nevertheless, UK courts and Chinese courts remain willing to determine global FRAND rates. German courts, however, are not, and US courts will do so only in certain types of cases. So there remains considerable tension among the various jurisdictions in this regard, and this in turn has given rise to calls from some observers, such as Lord Justice Arnold in his contribution to our book, for instituting mandatory arbitration of FRAND matters. And it is one of the motivating factors behind the European Commission's proposed CEP regulation, which we may hear more about later on. But for now, it remains essential for patent and antitrust lawyers, for judges, policymakers, academics, global corporations, all of us to understand the German perspective and how it fits into the overall scheme of things. And that is where I hope our book on FRAND cases and global perspectives will prove highly useful. Thank you.
We cannot hear you, Peter.
Does it work now?
Yes.
Okay, fortunately. So some issue with the microphone. So many thanks for those insights from the book, Erik and Tom. I would like to use the 1 or 2 last minutes of this part of the webinar to just highlight that German FRAND case law is nothing static. It's very much on the move, and we'll certainly see developments in that case law. And on the slide, you see a few of the factors which may impact the German case law going forward. There is, as you all have noticed, an amicus brief from the Commission floating around, sent to Munich court, and suggesting things which are at tension with important parts of German FRAND case law. For example, the so-called catching up, so remedying steps from the Huawei bans not undertaken prior to injunction litigation, remedying that during injunction litigation. The Commission seems to oppose that, which might, if the court follows suit, might bring more of initial damages litigation to sort of kick off litigation and then do the dance and then add the injunctions later on. And the Commission seems also to be pushing towards more FRAND condition determination by German courts. So we will see whether German courts will get into calculating royalties as the UK and US and Chinese courts already do, or it may be the German courts don't react to the Commission's proposals, or it may be, it remains to be seen, it may be that they ask the CJEU again. So this is certainly something which may alter the course. Then we have the UPC, a bunch of UPC FRAND decisions coming up, and it will be highly interesting to see how the UPC defines its approach to FRAND. Certainly this will also be studied carefully by the German judges. Some of them are both German judges and UPC judges, and they might be deciding FRAND cases on sort of with either of their hats on. Then, of course, we have the regulation. With the new commission, we'll see how the regulation proceeds. Many of you will have noticed that the commission issued a tender for a more like technical economic study on the regulation implementation, which doesn't sound so much like the commission giving up the entire idea just because there is a new commission coming in. So it may well be that we see a regulation in the coming months or years. And for one thing, the FRAND condition determination under the regulation may, of course, be yield important points of reference when, for example, German courts get into more of FRAND condition determination. And finally, there is FRAND also beyond SEPs, as you know, for example, in the EU Digital Regulation Acts like the DMA, DSA, there are various provisions referring to some sort of FRAND condition concept. I'm looking forward to participating in a study on that for the Commission in the coming months. So there is also intense thinking among policymakers about what FRAND might mean in other settings, for example, data settings. And their German FRAND case law may be an input giver a bit more than an input taker at the outset, but certainly there will be very interesting interactions between the various areas in which FRAND finds application. And I think we can all be very happy that Justus and the judges will now tackle a couple of these going forward points with us as the webinar proceeds. For example, the UPC approach to FRAND and possibly also the amicus brief a little bit. With that, Justus, I would like to hand over to you again, and thanks for making time.
Yeah, thank you very much to my fellow panelists, and I would now like to share some findings of our own recent study on the German case law on SEP injunctions, and I hope you can see my slides. This is joint work, and I'm very grateful to my co-author, Santiago Bergalo, who has been very helpful with the data analysis, and Professor Erik, who has been instrumental in facilitating access to the DARTS IP database. So I can be very brief on the background and motivation, thanks to the excellent presentation so far. Germany has, of course, been a leading venue for SEP litigation for several decades already. Where Germany really stands out is in the number of cases in which courts have been willing to grant an injunction in cases opposing an SEP owner and a standard implementer. I believe that much more than half of injunctions granted worldwide in such cases were granted by German courts. And since 2015 and the European Court of Justice's Huawei versus ZTE decision, of course, there's this framework that determines whether a request for injunctive relief is permissible. Application of this framework has varied, and then in 2020, there were these two additional decisions from the Federal Court of Justice providing additional guidance on the implementation of this framework. So as we have heard at length, and I'm not gonna further develop, this German case law has policy relevance and implications that go well beyond Germany, in particular in the context of current discussions at the EU level. What I want to present is this descriptive study that we have done. So it's really a purely descriptive study in the sense that we focus on the frequency of certain outcomes and do not purport to comment on what is the correct application of this framework, or we do not try to evaluate to what extent this application has been reasonable or positive. We do try to be as comprehensive as it was possible for us. So we have reviewed and coded 75 regional court decisions involving a FRAND defense and an injunction request. There are 5 additional decisions where we know the outcome and basic facts of the decision, but we had not access to the text of the decision itself. And then for each of these cases, we tried to see whether there has been appeals and higher instance decisions regarding this case, as well as try to identify parallel validity proceedings at the Federal Patent Court. And in a nutshell, to summarize the findings, I would say that the findings depict significant variations in outcomes over time, as well as across over courts. And they underscore some potential concerns regarding issues such as injunction gaps and the court's limited review of licensing offers. On a very general level, the descriptive statistics, we see that approximately 2/3 of the decisions in our data set have resulted in the grant of an injunction, but there has been significant variation over time. Most of the cases in which injunctions were denied are from a period that goes from roughly mid-2016 to mid-2018. In the earlier period, many transition cases were handled that were initiated prior to the Huawei versus ZTE decision. But then after 2018, we kind of returned to a very high rate at which injunction requests are granted. Similar and related to this, we see that the rate at which injunction requests are granted varies between courts, where in particular the regional court in Munich has a high rate, at least in our data set, unanimous rate of granting injunctions, and this can also be related to the timing, because at least in our data set, the regional court in Munich really appears after 2020 in a period when generally most cases resulted in an injunction being granted. One of the specificities of the German system is bifurcation, meaning that different courts hear matters related to validity and infringement. And it is a systematic feature, I would say, of patent litigation that the defendant party challenges the validity of the asserted patent. This is true both for cases in which ultimately an injunction is issued and cases in which an injunction is denied. What is important in this context is that the proceedings at the Federal Patent Court systematically take longer than the proceedings in the regional court, and they are also typically initiated later, so that there is what is called this injunction gap, meaning a period of time after the regional court has issued a decision, which might be an injunction, and before the patent court has ruled on the validity of this patent. So in our data set, this injunction gap is a bit longer than 400 days, so quite significantly longer than a year. And just looking at cases in which the regional court has issued an injunction, we do find that 52 cases, in 52 of these cases, 47 of these cases, the validity of the patent was challenged, and in at least 19 of these cases, the Federal Patent Court issued validity decision that conflicts in a way with the injunction decision, meaning that the patent was found either completely or partially invalid after the regional court had already issued an injunction. Speaking about the timing of the litigation, one of the things where German courts stand out also in comparison to the international peers is the speed at which decisions are issued. So most of the cases, the vast majority of the cases are decided within 2 years. And there's not much of a difference between cases that result in injunction or an injunction being denied. Where we do find some interesting variation is in what we call the pre-litigation negotiations. So the period between a party has made a license offer and the time where it initiates litigation, this period is significantly longer than the duration of litigation itself. And we do see that there are two types of cases in which patent holders tend to fare well. These are cases in which they either initiate litigation immediately after or in a short period after having made a licensing offer, or cases in which at least 5 years elapse between the time of the licensing offer and the time of the complaint. Another aspect or another characteristic of licensing offers that correlates with a very high patent owner success rate is if the patent owner participates in a patent pool related to this asserted patent. So there are 31 cases in our data set where we were able to explicitly find mention of a patent pool licensing offer for the asserted patents. And in 30 of these 31 cases, an injunction was granted. So patent owners participating in pools have been extraordinarily successful. And this is not even accounted for by the change over time, because actually most of these cases are from before 2020. And another aspect that we already heard about is that the vast majority of the licensing offers that are in our data set are explicitly worldwide licensing offers. And we actually have no instance in which a SEP owner relied on a licensing offer that was explicitly limited to Germany. And this has not been an obstacle to getting injunctions in Germany, as has been rather can be considered the norm in SEP licensing negotiations. So as we have heard, now moving to the analysis of the court's reasoning for the injunction, what is really the almost exclusive guiding framework for the analysis of an injunction is the question of whether there is abuse of dominant position. There are in principle other avenues under which defendants might seek an injunction to be denied, but empirically cases in which the dominant position, there was not a finding of abuse of dominant position in these cases, systematically injunctions were granted. The only exception in this data set is a case in which the patent had expired prior to the final decision. And then this an analysis of whether there's an abuse of dominant position typically is a two-step analysis. First is whether the patent holder holds a dominant position, and then the second is if in the affirmative it is found that he holds a dominant position, whether the patent holder had abused this dominant position. And the first question, which the literature has insisted quite a lot about, and on the importance that this needs to be assessed on a case-by-case basis, has in effect in the case law not played a major role, in the sense that, at least in our data set, it has been systematically affirmed that the owner of the standard essential patent holds a dominant position. So there are a few cases in which the courts felt that it was not necessary to assess that, mostly because they considered that if he held a position, then he had not abused it. And then to determine whether a patent holder abused the dominant position, this is really where the Huawei versus ZTE framework is applied. And as I believe most people in the audience know, this is follows different steps. So this framework follows different steps, and there are at least 4 steps in that process that are relevant here. And the first step is whether the owner of the standard essential patent has given sufficient notice of infringement to the accused infringer prior to initiating litigation. And there has been some welcome development in the case law on what it means for a standard essential patent owner to provide such sufficient notice. But empirically, this has not been an important factor in the case law, in the sense that this has almost systematically been affirmed. So I have not seen a case in which the court had considered that sufficient notice had not been given, and therefore a request of injunctive relief was denied. And the next step of the framework is whether the accused infringer has expressed willingness to license. And as we have heard, and as we will return to a little bit later, this, of course, has been a very important factor in the case law. So there are a significant number of decisions in which the court has found that the accused infringer had not been a willing licensee, and this has systematically resulted in the request of an injunction being denied. Once again, the exception is the case involving the expired patent. Also, cases in which the alleged infringer has shown willingness can result in grant of an injunction if, in the subsequent step, the SEP owner has shown to have made a FRAND offer. And but in the majority of cases in which the accused infringer has sufficiently established willingness to license, actually it was able to obtain rejection of the request of injunctive relief. And this leads us then to the next step, which is the court's analysis or the court's assessment of whether the SEP owner had made a FRAND offer. And we can basically see that the German case law on SEP injunctions is divided in 3 types of cases. There's one type of case in which the court assessed that the licensor had made a FRAND offer and therefore granted an injunction. There are cases in which the court assessed that the LCP owner had not made a FRAND offer and therefore denied the injunction. And then there are cases in which the court felt it was not necessary to assess whether the licensor had made a FRAND offer, basically because the accused infringer had failed to establish willingness and also granted an injunction. So basically over the total period, we can see that roughly half of the cases in which an injunction was granted are related to cases in which a FRAND offer was made, and the other half was related to cases in which the court felt that it was not necessary to assess whether a FRAND offer was made. And then we can further dissect these cases. So we can look at the analysis of whether a FRAND offer was made once again in two steps. So there are two sets of requirements. The first set of requirements are rather formal in nature. So this includes issues such as the offer has to be made in a timely fashion, and the LCP owner has to sufficiently explain what the offer is and how it is calculated. So this is what we in the study have called the formal FRAND obligations or FRAND requirements for the offer. And then the second set of requirements are more substantive, is whether the offered terms and conditions of the license are actually FRAND. And if we look at these two prongs of the FRAND analysis, we can see that courts have often assessed whether there is an offer that complies with these formal requirements, and relatively often found that there was no offer that complied with these formal requirements. So there are at least 14 cases in which an injunction was denied because of failure of such a compliant offer. But if a formally compliant offer was found, if an offer complying with these formal requirements was found, then in 80% of these cases, the SEP owner prevailed. So it is quite rare, and then actually in the majority of cases, courts explicitly stated that they did not need to assess whether there was an offer that was substantively FRAND. So there are two reasons why the court might decline to make this assessment, either because the licensee had failed to establish willingness or because there was no offer on the table that complied with these formal requirements. And then in the vast majority of these cases in which the courts did make an assessment on the substantive FRAND character, an injunction issued. So there are 6 decisions in our data set where an injunction was denied for failure of an offer on terms that are substantively FRAND. And in most of these cases, as an economist, I would say this is not related to the total cost of the license for the prospective licensee, but it's related to individual idiosyncratic provisions and terms and conditions of the license that were deemed incompatible with FRAND obligations. So there's actually only one case that I found where the court made something akin to a top-down analysis to determine whether the offered rate was excessive compared to the value of the technology. And given that we have identified these 3 types of cases in the case law, I think it's important to return to this analysis over time and also to take into account this rather significant Federal Court of Justice decision. And so what we have done here in this analysis is to just sort the decisions by the date of the decision. And we can see that we can really see these 3 periods in the German case law. So the first set of decisions were mostly involving transition cases, often resulting in the grant of an injunction. And then we have 3 years during which injunctions were often denied. And then since mid-2018, the vast majority of cases in which an injunction was requested, this injunction was granted. So this timeline itself does not necessarily align directly with the Federal Court of Justice decision, which was the first one was issued on 5th of May 2020. So there are already a stretch of very successful outcomes for ICP owners had already begun. But if we now divide this analysis into these different aspects of the injunction analysis, we see that since pretty much starting May 2020, we see that it has become very common for courts to find that the accused infringer is unwilling to take a license, which actually was quite rare in the period up to May 2020. So even in the majority of cases up to May 2020 in which an injunction was granted, the accused infringer had been found to be willing. And the other thing that was very rare until May 2020 was for courts to state that it was not necessary to analyze whether a FRAND offer was made, including in cases in which the accused infringer had shown to be unwilling. Courts did determine that the SEP owner had made a FRAND offer, and it was rare for courts to say that they did not need to assess whether a FRAND offer was made. And there are also cases in which courts stated that they did not need to assess whether the licensee was willing. So this clearly has reversed. Since May 2020, we see that courts very often do not see the need or just state that there's no need to assess whether a FRAND offer was made. And the willingness to license of the accused infringer is systematically assessed. And this is, in the vast majority of cases, the dispositive element of the case. So this is what I have in terms of the descriptive analysis. And I think this is now a good time to give the floor to our judges to offer their comments and perspectives on these findings, but also more generally on their views on the German case law. Thank you very much.